There are lots of us out here who believe that the justice system does not work. But I am here to inform you that if you are one of those, or if you meet anyone who says something like that, like our justice system does not work, you can inform them they are wrong. Our justice system actually does work, and it works pretty well. And today, for this video, we'd like to go through some of the instances on how exactly it works and how it works pretty much as it's designed to, and in a sort of balanced way to keep the peace and make sure the government and the state doesn't advantage the citizens, etc., etc. We are going to go through some articles and a recent story that proves the justice system is up to mark. Justice in and of itself is a very important thing, especially when we're talking about the justice system in the democratic countries that we live in. Even in times gone before, in monarchies, in dictatorships, in empires, etc., nearly every single kind of civilization would have had to have some form of justice because it's kind of important. Without justice, you have no peace. For those of us who are familiar with the protest chant, no justice, no peace. And that's actually kind of true, because what tends to happen is if you don't have an official recognized way to get justice, very often what you tend to see happening is people start to figure out their own independent ways to acquire that justice themselves. And when you have a bunch of independent justice seekers out there, you tend to have war, no peace. Everyone has their own reason for conflict. So justice is very important. And you could see it develop over time. A lot of people, sometimes when we look at the justice system, we could judge it unfairly sometimes, not understanding the history and the fact that this is probably the best it has been in many places for a very long time. It has been developed, at least the justice system that we have here, developed in Britain for probably what, like 1,000 years or so to some extent, and maturing over time till we have what we have now. And what we have now currently in Trinidad and Tobago and in the wider Caribbean and some members of the Commonwealth is a justice system that ultimately ends at the Privy Council, still in England there. And there are reasons for that because, as I said, justice is very important for peace and democracy. So having a trusted justice system is kind of paramount. The idea of justice requires the people to believe that the justice system is just. So we have that system that has been here for so many years. And recently there has been some discussion, some back and forth about whether we should remain with the Privy Council as we have done for a lengthy period of time, or we should leave and now move on to the Caribbean Court of Justice as our new final appellate court in the Caribbean, and well, Trinidad and Tobago signing on to that. But while that discussion is being had, decisions are still being made and cases are still being decided by the Privy Council, and today we're going to focus on one such case very recently where we saw some alleged perpetrators of corruption from since in the 90s in the Piarco Airport Scandal. They recently won a case at the Privy Council where they said there was some bias from a local magistrate, and they carried that case straight up to the Privy Council and they got justice. Now, to drop the punchline pretty early in the video, the reality is that although some may see this as justice, they could have only accessed that because they had very deep pockets. Now, we are going to go into the case to see if we ourselves could see how justice is executed here. If this is actually a case of real justice, or if this is a case of the Privy Council robbing us in Trinidad here of what we would have deemed as justice for us as a people, because the airport scandal back in the 90s there, where they rebuilt the Piarco International Airport, that was widely known as one of the darker points in Trinidad and Tobago's history, especially as relating to white-collar criminality. And if it is that a case is being lost as pertaining to that, is that really justice for the people of Trinidad and Tobago? And what we realize with this case as we go through it is that the case wasn't lost really on the merits of the case. It's not that they're saying, okay, these people did not steal money from the country. They're saying that in the process of finding out whether or not they really did in fact steal from you, the process wasn't done accurately, so now the whole case is thrown out. let's get into that. Before we dive into the story, make sure you hit that like button, drop a comment if you have something to say. The usual, share the video to someone who may like such content or someone who may be wanting to figure out what exactly happened with this case. Why are we not going to prosecute these people further than that? Is the Privy Council working against Trinidad and Tobago's interests? Well, share it to someone who would like to figure out those questions, and let's dive into this. Piarco accused could walk after Privy Council ruling. This is the article from the Newsday. The state's 22-year-old criminal case against a former government minister and a group of businessmen arising out of the construction of the Piarco Airport Terminal building has been thrown out by the Privy Council on Monday. They had been charged with a multiplicity of offences. In a 26-page ruling, the law lords wrote that the decision of late Chief Magistrate Sherman McNichols to commit the accused to stand trial was tainted by apparent political bias. We're going down to the end of the article here to just get a little summary and a little refresher of what this entire incident is really about. The Piarco cases. The charges against former government ministers, a group of business people, and public officials stemmed from a multi-million-dollar investigation by Canadian forensic investigator Robert Lindquist in 2000 and 2002. The first group were charged with offenses alleging theft of $19 million during the construction of the Piarco Airport Terminal between 1995 to 2000, in what is commonly referred to as the Piarco 1 corruption charges. Those charged in that case are former finance minister in both the PNM and the UNC administration. He was on both sides of the aisle, Mr. Brian Quaitong, former PNM National Security Minister, and Attorney Russell Huggins, former NIPDEC Chairman Edward Bailey, Maritime Executives John Smith, Steve Ferguson and Barbara Gomez, Ishwar Galbaran Singh, Chairman of Northern Construction Limited, Amrit Maharaj, Financial Director of Northern Construction Limited, businesswoman Renee Pear, then Quaitong's companion. Smith was murdered in July 2021, and Bailey died after a prolonged illness in 2006. In 2006, multiple charges were filed against several people, including American businessmen and companies, in a broader conspiracy to steal over US $200 million by setting up ghost companies in what is referred to as Piarco 2. So this case that was decided by the Privy Council was Piarco 1. Bear in mind, that's not all the cases around Piarco. There's another case alleging theft of US $200 million, and that's Piarco 2. Those charged in that case include President of Calmaquip Engineering Corporation, Raul Gutierrez Jr. of Florida, the principals of Burke Hillman Consultants in the airport project, Eduardo Hillman Waller and Ronald Burke, also of Florida. In 2007, Gutierrez, Hillman, Waller, and Burke pleaded guilty to similar charges in Florida and were sentenced to prison terms ranging from 6 months to 6 years. They also agreed to pay US $4 million each in compensation to Trinidad and Tobago. So this is the part that kind of offends me when I think about a lot of things pertaining to this case. The foreign defendants, those guys out in Florida who also stole our money, they were already convicted, charged, convicted, spent time in jail, came out of prison by now, paid back Trinidad and Tobago some money, and we are still trying to figure out how possibly to continue the cases on the guys down this side. Something doesn't quite add up there, but I am heading over to the Privy Council's official write-up of this case for us to get a breakdown of exactly what happened here. I find, if it's one thing I must give the Privy Council, I read previously out of some of their other cases, they have nice, concise write-ups. If you're trying to figure out what is going on, you could literally head over to their website and read the cases there. It's written in English. You could understand it. So this one is the case of misjudgment of Mr. John Henry Smith and other appellants versus Attorney General of Trinidad and Tobago. So we're going through here to get the breakdown of exactly what happened. these appeals from two related decisions of the Court of Appeal of the Republic of Trinidad and Tobago concern an application for the recusal of a judge presiding over criminal proceedings on the ground of apparent bias. They arise in the context of a long-running and extraordinary set of circumstances. The test for such a recusal is whether a fair-minded and informed member of the public who considered the facts would conclude that there was a real possibility that the judge was biased. Sometimes it is asked whether there is a legitimate doubt as to the tribunal's impartiality, a quality seen as indispensable to the fair administration of justice. At the outset, it is necessary to record the background circumstances of this in some detail. All right. So basically, this first paragraph here sums up the entire idea of what they're talking about here. The crux of the case that they have to decide is whether the chief magistrate at the time would have been seen as being biased. Now, they're not determining whether he was indeed biased or not. This is not what they do. There's no way they could really determine that to be factual for sure. So the determining factor here, as quoted by them, and this is kind of important because it plays over and over through the entire case, is whether a fair-minded and informed member of the public who considered the facts would conclude that there was a real possibility that the judge was biased. Now, every part in this is kind of important to understand in order to get to that ruling. A fair-minded, that's kind of self-explanatory, informed, so they have to know the facts of the matter and they have to consider the facts of the matter. All right, so they go down breaking down the initial facts about the preliminary inquiries into the Piarco scandal. The appellants were senior officers of insurance companies. Along with others, they were charged with various fraud and corruption offenses arising out of the development of the Piarco International Airport in Trinidad in the 1990s, at a time when the United National Congress, UNC, was in government. In December 2001, the People's National Movement, PNM, came to power. In 2002, an Anti-Corruption Investigation Bureau was established within the Ministry of the Attorney General. Under its auspices, various criminal proceedings were brought concerning the awarding of airport contracts and related matters. There were 4 so-called preliminary inquiries in the nature of committal proceedings known as Piarco 1 through 4. As we said before, this initial case has to do with Piarco 1. So we aren't going to go through all of this. It's quite a bit. The judgment is there on the Privy Council's website if you'd like to go read it through in entirety. It's quite a bit, but it isn't impossible to read through. It's like 26 pages. Feel free. But we'll summarize it. The main character in this entire matter is the former Chief Magistrate, Mr. Sherman, well, His Excellency, His Worship, Chief Magistrate Sherman McNichols. He is now deceased, and he is the main player in everything surrounding this because there were several investigations going on. He was the chief magistrate in charge of looking over the preliminary inquiries. Now, before we get into this current case, there was another case previously decided that had to do with former Prime Minister Mr. Bastio Panday. In July 2005, the Chief Magistrate purchased a plot of land for $3.6 million from Home Construction Limited, which was a subsidiary of CLECO. The purchase and its funding placed significant financial pressures on the Chief Magistrate. Soon afterwards, he sought a buyer for the land, but without success. So Mr. Chief Magistrate bought a piece of land from CLECO. All right, he was struggling to continue paying for that land. Quite separately from the Piarco inquiries, on 20th of March 2006, a summary trial began before the Chief Magistrate in respect of a charge that when he was the Prime Minister, Mr. Panday failed to declare funds received and held in a UK bank account. I don't know how many of you would remember that specific trial, but Mr. Panday was accused of receiving some money from a CLECO executive, Mr. Lawrence Dupre, but the defense for the matter from Mr. Panday and a senior Hindu representative, religious representative, was that in traditional Hindu households, the woman takes care of the finances. This was the actual defense posited in court. And then, on the other hand, Mr. Dupree said that the money was a gift, a scholarship for his daughters as they studied in the United Kingdom. So that case was before the chief magistrate back then, Mr. Sherman McNichols. Now, allegedly, on the morning of 27th March 2006, which was the last day of evidence when Mr. Dupree was testifying, later that very same day, Mr. McNichols, the chief magistrate, organized for the sale of his land back to Clico. A representative of Clico offered him a $400,000 down payment for it, and he asked that the representative of Clico send it over as soon as possible. The money arrived the following morning in the form of a banker's draft drawn on the account of Caribbean Money Market Brokers Limited, another Clico company. The chief magistrate deposited it in his bank, where it was credited to his account. So there's where the bacchanal start. Chief magistrate bought land from Clico before. He's struggling financially. He's trying to sell it. Clico is looking to buy it back now. They made a down payment of $400,000 and paid it to him. At the same time, he is overseeing a case where where the former prime minister is being accused of receiving bribes from the very same Clico. You could understand how things start to look a little shaky already. Apparently, soon after he received the money and deposited it, he used it. He used it to clear some of his debts and pay back some of the overdraft that he had in the bank. But then quickly after that, he reversed what he was doing and he spoke to his banker and said that he's in a bit of a fix, and the bank issued him a $400,000 check that he returned to Clico and he paid back, because he was saying that he felt that this looked like a trap. It wasn't seeming right. So after he got the money, after he used it, he then figured out it seemed a little trappish, so he returned the money. He already received it, just by the way, already deposited, then reversed that process. However, on top of all of this, even on top of all of this, there was some bacchanal between, back then, the chief magistrate and the chief justice concerning the same Panday trial. The chief magistrate alleged that the chief justice was pressuring him to decide favorably in Mr. Panday's favor to throw out the case. That was his allegation. The chief justice said certain things to him, told him which lawyer to pay attention to, and told him that he believed, the chief justice told him, allegedly told the chief magistrate that he believed this was political persecution, so you should kind of ignore this case. That's the allegation from the chief magistrate. On top of all of this now, you could kind of see how this story, the story is getting thick. The bacchanal getting thick in this whole story. Pursuant to that, following that, the Attorney General got involved. In or around March or early April 2006, the Chief Magistrate told the Attorney General, John Jeremy Senior Counsel, that the Chief Justice had tried to influence his decision in the Panday trial. He also mentioned the $400,000 payment. According to the Attorney General, the Chief Magistrate told him that a land transaction had inexplicably been activated by a down payment and an offer to purchase the land made by a Clico subsidiary. The Chief Magistrate said that he was troubled by this, and so he returned the deposit. Now, that's not the full details of the matter, and because he withheld some of the details of the matter back then, it actually worked against his favor in the long run. But he reported that to the Attorney General, and the Attorney General got involved in the case. The Attorney General spoke to a friend he had inside of Clico. According to the Attorney General, it was after the conviction when he met with Mr. Andre Montoya, an old friend and a senior Clico executive. He told him that he had reason to believe that Clico had attempted to bribe the chief magistrate and that they should clean up their mess. If, however, the transaction had been in good faith, the chief magistrate should not suffer through being overly cautious in returning the check. That line there is where some bacchanal happened. Because on 28th of April 2006, Mr. Montoya asked Mr. Michael Fifi, HCL's chief executive officer, to buy the land back from the chief magistrate. He was reluctant to do so because of the disagreements previously, but eventually they went through, and bought the land back again from the chief magistrate. So the chief magistrate got this suspicious land deal according to him. He took the money first, he returned the money after he spoke to the attorney general. The attorney general spoke to someone inside of CLICO, told them to clean up the mess. But he said, if indeed it was not a bribe, then you shouldn't have the chief magistrate worried about this. So they sent back the deal, they reoffered the deal to the chief magistrate. Bear in mind, through all of this, the chief magistrate was already noted to be in some financial difficulty. So even by CLICO just returning the offer to buy the parcel of land again brings certain things into question. And then that offer back from CLICO was kind of brought by because of the then Attorney General. So you could draw a possible reasonable conclusion that the Chief Magistrate might have some favor to return to the Attorney General. Following all of this, time continued to elapse. Of course, they have a pretty detailed account of it. This reads like kind of like an interesting story, to be very honest with you. So it went on, and eventually the whole bacchanal, the whole issue between the Chief Magistrate and the Chief Justice came to a head. All while this was going on, he was deciding part of this case for Piarco 1. Now, Piarco 1 is the case that was before the Privy Council. So all while this was continuing, he was deciding the preliminary inquiries for Piarco 1. While that's being done, prosecution eventually opens up against the Chief Justice. So we now know there's some friction between the Chief Magistrate and the Chief Justice. An investigation, prosecution starts to happen. On 3rd of February 2007, the Chief Magistrate wrote to the DPP inviting him to stay the prosecution of the Chief Justice pending the anticipated Section 137 proceedings. So the DPP, hearing this bacchanal, he started investigations and prosecutions against the Chief Justice. The Chief Magistrate then said, you know what, nah, I don't want that kind of prosecution. There's a constitutional investigation that is going to be set up, and that's where I want it. But unfortunately, the DPP is independent of all of this. He is going to prosecute what he sees to be the criminal misconduct, if so be it. Now, what eventually happens, the Chief Magistrate is called on to testify against the Chief Justice, because remember, in this whole case against the Chief Justice, he is the main witness. He is the one that allegedly the Chief Justice tried to pressure to sway one way or the other. Now, he refused to testify. The Chief Magistrate refused to testify in that case against the Chief Justice. That brought him into even more disrepute and under an even greater cloud of suspicion. If you're saying the guy is corrupt and trying to influence you in a certain direction, why would you not testify? Now, where things started to go south already was on 4th of April 2007. The Court of Appeal quashed Mr. Pandey's conviction because of the appearance of bias on the part of the Chief Magistrate. So, the case that the Chief Magistrate decided on the whole Pandey matter with the receiving of the alleged bribes from CLICO was quashed not because he didn't receive the alleged bribes, but because the Chief Magistrate showed himself to have bias. Now, in this case, he was deciding something against the UNC's leader, while at the same time being involved in some kind of bacchanal with land, where eventually he gets the purchase of some land from CLICO through the intervention of the Attorney General. That seems to be apparent bias. In his judgment back then, Archie, who was then a Justice of Appeal, explained that whatever the truth of the conflicting assertions or the motivations for the actions taken, the inescapable conclusion was that a fair-minded and well-informed observer would conclude that there was a real possibility that when the Chief Magistrate decided the appellant's case, his mind was affected by unconscious bias. He had received what he suspected was a bribe connected to the evidence of Mr. Dupree. Also, the Chief Magistrate had said that he was the subject of improper pressure from the Chief Justice, his administrative superior, and the chairman of the JLSC, which exercised disciplinary control over him. So, if you were saying that you were under pressure from the Chief Justice, if you were saying allegedly you believed you received a bribe, possibly from someone attached to the case, it's hard to say that you would not have had in your mind some kind of undue pressure, undue bias one direction or the other. So now we have Mr. Panley's case already decided that there seemed to have been some bias back then. Just the fact that the Privy Council has that in there already says, it already signals the direction they are looking in when they are seeing this, how they are seeing this. On 10th December 2007, some 10 days before the Muster report was presented and published, now the Muster report would have been an investigation into the Chief Magistrate's action, why he refused to testify against the Chief Justice, etc. Right before 10 days before that report was released, counsel for the appellants and their co-defendants invited the Chief Magistrate to recuse himself from Piarco 1, failing which to refer the matter to the High Court under Section 14(4) of the Constitution. They made a request to the Chief Magistrate that, sir, please recuse yourself from this matter. We are saying that there may have been political bias in it. And this, I think, is where we see the main mistake that was made in nearly all of this case, why we may not be able to get any justice as a country for the actions that were taken by these particular defendants here. Because when he was asked to recuse himself, he could have recused himself and put another magistrate there, send it over to the High Court, something else. But no. On January 7, 2008, the Chief Magistrate delivered an oral judgment in remarkably peremptory terms, simply refusing the defendant's recusal applications as being without merit. No reasons were given. Under Section 14(4) of the Constitution, he was required to grant an application to refer the matter to the High Court unless the applications were frivolous and vexatious. When this was pointed out, he added that they were frivolous and vexatious. At the conclusion of the hearing, the Chief Magistrate committed all the defendants to stand trial on the new charges. To date, no indictment has been filed and the trial has not taken place. So this was just a trial on whether they should stand trial. And he decided yes. And he decided not to recuse himself. And he gave no reason for it. While good reason was given why he should recuse himself, he gave no reason why he shouldn't. He just said, frivolous and vexatious, thrown out. And now we are facing the consequences of that decision. From here on out in the judgment, for the most part, they go through the proceedings as they proceeded through the lower courts, High Court, Court of Appeal, and eventually into the Privy Council. But this here is basically the summary of the case they had. And I would like us to take a listen to this and see if the decision that the Privy Council ultimately comes to seems like a just one to us. Even if we may look at this and say, well, yeah, our money was stolen and we'd like some of it back, the proceedings still need to have justice inside of it. It had been contended that apparent bias resulted from the significant financial and other advantages in favor of the Chief Magistrate at the behest of the Attorney General, who had an interest in the airport prosecutions, was actively seeking convictions, and was also pursuing litigation abroad in connection with the same allegations. The Chief Magistrate was said to be beholden to the Attorney General for a number of reasons, including bringing about the repurchase of the land and thereby resolving his severe financial problems, for supporting the Chief Magistrate when the Chief Justice raised concerns about the impropriety and misconduct regarding the receipt of $400,000, and for siding with him in his allegations against the Chief Justice. The Attorney General also helped to ensure that the Chief Magistrate did not have to testify in the criminal trial. It was submitted that all of this suggested that the Chief Magistrate may have had a disposition to adjudicate in a manner which would find favor with the Attorney General. Reference was also made to concerns arising from the looming JLSC disciplinary charges, etc., etc. So, hearing the main matter here, the main case that says he may have been biased, listening to that as attempting to be a fair-minded, well-informed observer, do you think that there may have been possible bias there? I do not find that to be a hard case to make. If in the end he ended up getting his land bought off, his financial problems cured. He got the Attorney General in his favor against the Chief Justice. All of that may have been coincidental and may have happened all above board, but you can understand why someone looking at this from the outside would say, this does not seem totally free from bias. And the fact is, part of what added to all of this is that the prosecution of this entire thing, the prosecution of the entire Piarco matter, came out from the Attorney General's office. The Attorney General is a political actor. He is from a political party. If the prosecution is coming from the Attorney General's office, and then it seems like the magistrate themselves is having a little favor to the Attorney General office too, you understand where the bias suggestion comes out from. It's not something very difficult to see. And I think in some of this, it shows you why so often a lot of people are very careful about everything surrounding a court case. Now, I understand why this must be, because the state has so much power that you don't want it to be. The state is able to have an arrangement agreed between the Attorney General and the Chief Magistrate, and because of that, they engage in political prosecution. They are able to send who they want to jail. They are able to make sure who they don't want to go to jail don't go to jail. That's not a country you want to live in. So you understand why in the legal practice, in the law, you have so many provisions to protect people from things like that. You have provisions to protect people from that kind of bias. You have provisions to protect people from what seems to be unfair prosecution. However, if you look at this case, if we are to deem that, yes, it seems like in this present case, there may have been some kind of unfairness going on here. It seems like some bias could be possible. The only reason these defendants were able to find that justice was because they could have paid their way to the Privy Council. And that's the thing with justice. I think a lot of the problems in the justice system, if you are able to pay your way to the end of the justice system, a lot of those problems are fixed. You are able to get justice, you are able to get what you deserve. Many of the times that happens, but the problem is you have to be able to pay it all the way to the end. And you not only pay it, but pay it over the length of time that it's going to take to do that. Recently, there was a symposium, a discussion, a conference, if you will, held by the Senator Dharma Mahasabha, and they spoke about the change from the Privy Council to the CCJ. And many of the speakers were against it. A former Minister of Finance, Ms. Karen Nunes Teixeira, she came up and she said some things in favor of moving to the CCJ. Now, I don't know necessarily which one I am sure in favor of. I understand the arguments of the Privy Council. Even the fact that it's outside of the Caribbean actually makes it a positive in some extent to me, where justice could be seen as not being hinged or linked to the different sways and political feelings of the moment in a given country. I could understand that argument. However, the reality of reaching to the Privy Council, the money, the cost of it is prohibitive to the average person. I found a little snippet of what Ms. Nunes Teixeira said, and let's listen here.
And what does it mean to get to London? To get to London, you have to pay the airfare of the attorney, and usually you will go with a junior, his hotel accommodation, his per diem allowance, and very importantly, the solicitor's firm in the United Kingdom who acts as agent for your local firm. When you added those costs, and they're all in pounds sterling, in one of the most expensive cities in the world, I can assure you, I'm not speaking out of, I'm speaking from personal knowledge. When you add those costs, it may end up being the cost, not in my case, perhaps that is why I have persisted, but in many a case, those costs alone may be the damages that you're seeking. And
that's just the reality of it. The cost of reaching to the final extent of justice in our system is out of the reach of most people. And if the cost to get justice is not in your reach, then justice is not in your reach. And what she went on to describe is that if you look at most of the cases in front of the Privy Council, they involve the state or they involve private enterprise, involve big companies, because that's just the reality. If you reach to the highest level and you're in a case against someone and the person says, okay, I'm going to appeal that, and you don't have the money to go up with them and defend what they are appealing against you, then you have no choice. You are losing by default. So is that really justice? I don't think that's really justice. However, I will say that our justice system does work. It does work. And to me, the evidence in this Privy Council matter, when I look at it, I could actually see the bias that they talk about. Trying to be a fair-minded, well-informed person, I could look at that and I see the Chief Magistrate's actions don't seem to line up with proper behavior. And in this case, you might think, okay, that's fine because it's people that stole our money and we want the money back. But if you think about the principle behind that, you do not want to live in a country like that. At least I do. That's all I have for now. Drop a comment, tell me what you think. Do you think the justice system works once you're rich? Or do you think even if you're rich, it still doesn't work? Drop a comment, tell me what you think. That's all I have for now. I hope you're educated, informed, or entertained, and I will see you later.